This year, our coalition, led by David Cameron, has launched a series of savage financial attacks on our nation. They have stripped support for some of our most needy, including elderly people, single parents, disabled and sick. If you have previously needed any form of financial assistance from our state, then it has now been severely, troublingly reduced. So while tax avoidance for David Cameron's city mates grows by the billions, people who have lived in their council homes all their lives and certainly for decades are now being forced out because they can no longer afford one single spare room. It's deplorable, of course, but this government's attack on our people is far from over. Now they have started on our legal aid system and are removing support, so it will be harder for low-income people to access justice, including should they ever need to challenge government bodies. Here is an interview with Lee Mott, a criminal defence solicitor, who kindly shares his very real, very deep concerns about this assault on our justice system. What I'd like to know, Lee, is in your experience, who will be most affected by these cuts to legal aid?
Well, the vast majority of work I do is legally aided, so people already are subject to a merits and means test for legal aid, certainly in criminal defence work, and they have always been for civil work as well, certainly in recent times. So the people that get legal aid now are people that, under fairly stringent financial requirements, have to qualify. To put it into context, in criminal legal aid, you have to earn less than £12,500, a bit less than that actually, gross, before tax is deducted a year, or beyond passport benefit. That is effectively the position you need to be financially to qualify for criminal legal aid in the first instance. So to debunk a myth, not everybody qualifies.
Right.
That's the magistrate situation. In the Crown Court, people are given legal aid even if they're above those means, but they are exposed to 5 monthly payments based on an average cost of a particular type of case. And in those cases, if they don't pay, they get a 6th penalty month payment. And obviously that's because the cases are so serious that obviously representation, most often for cases such as, your indigestible owners, such as robberies, murders, rapes and so on, it really probably wouldn't do to have a lot of people represent themselves, and that's as much for the court's benefit as anybody else. A lot of people have alcohol problems, a lot of people have drug problems. You can imagine that's the case in acquisitive offending, which we mean by theft, burglary, handling stolen goods, frauds, those sorts of things, that are very low incomes, but incomes often that aren't sufficient to fund an addiction. But, and in many ways it comes with a two-pronged approach here. There is currently a review of antisocial behaviour orders, which the local borough here in Swindon are in the position to apply for, freestanding, without any criminal offences. Now we represent those as well, and I'm deeply concerned about those, and it's particularly an area of concern that you may have, in that the vast majority of people that the council seek antisocial behaviour orders about, and there's a very good lawyer at the council who's a very fair man, but he will almost certainly agree with me, a lot of them are against young people, youths in the eyes of the law, so 17 and under, and a lot of the adults that they seek antisocial behaviour orders against very often have mental health issues or certainly vulnerabilities. And they're planning not just to reform ASBOs to take them out of the criminal courts and put them in the county courts for adults, or indeed even use with adults. That is one reform ongoing, but of course the other one potentially is the changes to legal aid that the current Lord Chancellor is proposing, which are extraordinarily damaging.
That sounds very troubling to me, actually. So I've been looking at the sort of breakdown of what all of this so-called review entails, and a number of things that I'd like you just to help me understand a little bit more. One of them was, obviously, there is the issue about introducing competitive tendering, which always, whenever I hear that, when it comes to sort of anything that involves the public, always scares the life out of me. Could you tell me a little bit more what that actually means?
It should horrify the public.
Okay.
Absolutely horrify them. In this, Chris Grayling, the Justice Minister, has managed to achieve what no other politician has achieved before. And I don't just mean in terms of the severity of the proposals. He's actually, to all intents and purposes, united the criminal bar, that is the barristers that do defence and prosecution work, and the criminal defence solicitors, which is extraordinary because normally there's been a huge gulf between us, often the interests clash.
Right.
But on this, there is almost absolute unity. And there's a marvellous man by the name of Michael Turner QC, head of the Criminal Bar Association, who's doing a lot of very high level shouting about this. There are MPs, some MPs, on all parties actually, there's a few in each party as I understand it already, who are deeply concerned. I
mean, my experience very much is that unless it affects the country in terms of financial terms, people tend not to go into uproar about this, but this is obviously clearly going to affect us all financially. Why are people not, is it just that people are not aware of this?
Well, I think so. The governments over the years, and I don't just lay this at David Cameron's door, because Tony Blair, one of the first speeches he gave was about the legal aid gravy train, which was non-existent when he gave it. And I'm afraid governments historically, certainly from Blair, maybe even before that, have been busily undermining the public's view of criminal defence laws in particular, but the criminal justice system. So we are seen as, and some papers will still peddle the fat cat line about lawyers.
Well, but it's a known propaganda tactic to attack that sort of structure, because that's what happened with the NHS. They focused on the so-called, well, actually, yes, in many respects, the fat cat managers. So it is an absolute well-known propaganda tactic, and I think obviously it's designed for the public not to have any sympathy with you, for us to say, well, you lawyers, you're making a fortune. But what people are obviously overlooking is there is a much bigger issue involved, not least, as you say, that is actually far more rare than we're led to believe. But we are also talking about the fact that people will be denied access to justice, but not even just that, but also denied the choice of who they need to accompany them through the justice process.
And I think that's where me and my colleagues are actually going to have to focus our attention. Put price out of the picture a moment, because it is largely a red herring. Right. And the other problem is, should, for example, Tesco's bid to provide defence lawyers, how are they going to defend people that steal from Tesco's? Because of course they're the injured party, as well as the defending lawyer.
Yeah.
G4S, for example, if they're supplying the cells to a court, are they also supplying the defence lawyer? Will it not look like the worse their lawyers are, the more business the cells get, which is the same company? Capita do the interpreters, they're supposed to be independent, but they're not if the defence lawyer works for the same company. Right. We have strict guidelines and ethics. We cannot have conflicts of interest. My colleague today in court this morning has had to say no to somebody because she represents the other half of the equation and they disagree. We can't represent both people. Right. So there are very strong ethical guidelines to the way we work.
Okay, I'd like you to explain something else to me, and as briefly as you could, if possible, and that is the judicial review. How is this going to, because obviously the judicial review cases, there seems to be an issue involved here, and obviously not being terribly au fait with the legal establishment. What does that actually mean?
Well, judicial review is the mechanism you use with the High Court in this country to challenge decisions made largely by government bodies, but also by local authorities, sometimes even by corporate bodies.
Right.
When decisions are they made correctly, following the right consultation procedures, for example, and the right regulations that are out there in terms of, for example, environmental protection and so on.
Right.
So the classic example would be large-scale capital projects, like the rail link perhaps that is planned for London to Birmingham, where you have maybe a site of scientific interest that they're planning on putting the railway through. Is there something there, a rare species of snails we've had and bats and things like that, but have they actually gone about looking at that and assessing it properly and whether they've made the right decisions? Now, it can be very important because it can challenge government policy, certainly large-scale planning policies.
Okay.
And it is a direct challenge to obviously the government and their decision-making and indeed local government.
Right, well now that concerns me greatly because my understanding of that particular cut which now means that a judge will have to agree that the case is strong enough.
Well, as I said, there are many people who may have a nightmare scenario about what's going on. It's not unfounded because if you look at the various initiatives that come in, a lot of it's under the guise of we need to cut back, there needs to be austerity, we need to save money. Well, the question you need to ask is, where do you need to save money from? Are there effectively what the government, I suppose, would call red lines that you just simply shouldn't cross? Now, the problem as I see it is having a look and not being knowledgeable about the issues as you are about vulnerable people in particular to do with welfare and housing, and obviously issues about claiming benefits and so on. Those have been brought in. You have the benefits cap, you have the bedroom tax and all of those. So that has already harmed and hurt, financially certainly, if not in other ways, vulnerable people. You then look at the civil legal aid cuts which have come in, and they curtail advice for, funnily enough, welfare, housing and so on. So that adds a tier to that. You've then got an attack on judicial review, which of course may narrow access to justice for people that want to challenge obviously large-scale governmental potentially decisions. So you have that. Then you have an attack on criminal legal aid, which of course may result in, certainly the government would say, still a person representing you, but not nearly of the quality that obviously, and not nearly of the skill that we now have available. It's a resource. I mean, I believe the defence services this country, barristers and solicitors, are a resource and a valuable one. It's something that the government has always championed. The valuable criminal justice system is one of the highest quality ones in the world. And I'm afraid if you look in the consultation paper, you will find a paragraph that says that really all that defence representation needs to be is adequate. And I kid you not, it is there. They say that there's almost a punitive element, that if you're going to offer service at a higher quality than adequate, well, really, you probably shouldn't be doing it.
I find that very troubling.
It's how it reads, and as I said, I'm perfectly happy to provide the reference to it, but it actually reads that really it only needs to be adequate. Well, it needs to be equal to the prosecution. Now, whether they'll start on the Crown Prosecution Service next and try and downgrade the quality, or maybe even privatise that, one doesn't know. There are murmurs about that too. And the worrying thing is that most Crown prosecutors, whilst they're prosecuting, would try and achieve a fair result. As a minister of, ironically enough, justice, they would read the facts up, but they don't stick the knife in. They don't say the person should get this penalty. So that's another attack. So when you look at all of these things across the board, and there will be other things, for example, just yesterday they bring out another consultation paper, and the Ministry of Justice seems to be firing these out like confetti about victims, ironically enough. Well, if you view the two, criminal legal aid cuts and the victim consultation paper together, are victims going to be better off or worse off if they are cross-examined by a litigant in person, a client without a solicitor? A solicitor is trained to cross-examine somebody properly. We're not, and there are no points for reducing people to tears like the television shows. There's no point in having somebody reduced to rubble in the witness box. It doesn't do your client any good. They effectively think that our client has instructed us to do that. And the classic example is youth trials. Am I going to get any sympathy from my client if I savage a 13-year-old that's come to say that they were bullied at school? No, I'm not. I need to say to them, you may not be right, but that's the manner in which you say it. You don't say, you're lying, and then you try and downgrade them and diminish them. And victims will be affected if they are cross-examined by our clients direct who don't have the skill.
So tell me, what is the worst case scenario of all of these things? All of these different reviews coming into play. Could we ever reach a stage where somebody seriously does not have somebody to represent them? I mean, I know what you were just saying there, but you know, somebody who has nobody. Is that possible?
Yes, it is. It's eminently possible. With the system that looks like it's coming in, firstly, you will have almost your defence lawyer chosen for you.
Right.
Secondly, they may not be one of the current crop of criminal defence advocates, so they may not be properly qualified. I don't know what they're going to do about the quality. They talk about quality, but it's very much secondary to cost cutting, it seems to me. So that's a worry. You have, you mentioned earlier, a possible total cap on legal aid full stop. If you earn above a certain level, those people, although they may not be legally qualified, or although they may not be obviously in any way unintelligent, but they may not be able to put their case under the rules of evidence or properly in court. And you can have that in very serious cases, potentially. So that is certainly the case, yeah.
I mean, that's almost Victorian, isn't it, really, in its
attitude?
It's really, really worrying.
Yes,
so is there anything we can still do? Is there any way that we can still fight against this? What can we do?
Well, the danger with the criminal proposal at the moment is potentially those don't need primary legislation, which is really worrying. So it means that potentially Parliament will not debate them unless there's enough support. Now, there are MPs that are appreciating the full horror of what the criminal justice system may descend into, and they are pushing for a debate in Parliament. We have, and indeed I'd encourage anybody that wanted to, we have written to the Judicial Standards Committee, the committee that judges the Ministry of Justice effectively and oversees them. I have emails back with enough emails and certainly with enough responses to the consultation paper currently out, and we're to copy our responses to the consultation paper to them. They hope to be able to hear evidence and have Mr Grayling in front of them to explain what he's doing and take evidence from him for that. There is an e-petition, Save UK Justice e-petition. It has about 25,000 signatures. We need 100, as with all of these e-petitions, to force a debate via backbench.
But even then, they just often ignore them anyway, don't they? So.
Incidentally, there's one on saving the probation service, which they're also trying to privatise at the same time.
Okay.
That should worry the public as well, because the probation service supervise some of the more serious offenders in the community. Now, the government has said it may keep probation non-privatised for the serious offenders, but who draws the line?
Yes.
What is a serious offence and what isn't?
The quote that Chris Grayling said was that criminals should bear own legal costs. I found that a very troubling statement for anybody to make. What do you think he means when he says criminals should bear own legal costs?
Well, it sounds to me as though he wants our clients to pay us. We've always had a troubling position, particularly since the money laundering regulations were tightened, in that, bearing in mind we are representing people accused of criminal offending, if they do have a lot of money on them all of a sudden, where does it come from?
Right.
That causes us problems with our regulators in terms of money laundering problems, because of course it may not be legitimate money. And I've seen the Process of Crime Act used in cases where in effect the prosecution is saying, well look, you've got all this stuff, but where's it come from? And they can't actually prove where it comes from. And they, in my view, certainly probably should be able to show at least some origin that is obviously not lawful. So that's the first worry for us. The second is how. The vast majority of people we represent are still under those thresholds for legal aid, that are still under 12,000 that get it automatically, under 22,000 that with obviously various expenses in children, would still get legal aid. What does Mr Grayling expect they're going to pay us? What sort of rate do they think we're going to be paid at? Because it seems to me that if they pay us at all, it will be next to nothing, and frankly, something they can't afford.
Right.
So it really does leave most people in a situation with, shall I pay my solicitor or shall I eat? Well, I think we all know the answer to that, and that will mean the vast majority of clients I represent at the moment making the choice of the latter. They need to eat, they need a roof over their heads. With benefit caps and welfare cuts, they're in the position where they simply wouldn't be able to afford a lawyer, whatever rates. And bearing in mind that even under legal aid rates, our charges for files actually are very modest. We could do a guilty plea case for £170.
Right.
Those are the sorts of levels that even at the moment privately many of us charge anyway. But that's still too much. £170 is a lot of money if you don't have it and you're on benefits.
Is there a danger here that we could have more miscarriages of justice as a consequence
Yes.
of these reforms?
Without doubt. Part of the reason I do my job, as you can probably tell from my age, and I hope you judge it right, is that I spent a lot of the early 80s looking at the front of the Royal Courts of Justice. Obviously, I'm not living there. I saw it on television a lot. I saw a lot of people outside the Royal Courts of Justice with their arms raised, having been released from custody because of the miscarriages of justice that happened in the 70s. That's part of the reason I do what I do. Now, how is it saving money if people have to be having constant appeals and having convictions overturned when they shouldn't have been convicted in the first place? How is it going to save money when these people are sat in prison for years when they potentially shouldn't be? And there is a very real risk of it. Even now, it is very difficult to do an absolutely proper job under what we are paid now. And as I said, the figures are massaged all over the place, but the fact is that on the consultation paper for criminal, if you look, what Mr Grayling is peddling is a figure of just over £1 billion for criminal legal aid. If you look at the LAA, the legal aid agency that now run the legal aid, they're actually prospectively saying that this year 941 million is the actual spend. And if you take the figures and boil them down, effectively the government's trying to save 220 million. They've already saved 160 million of it in those figures, the difference between the consultation paper figure and what they expect to spend this year. They need to save £52 million. That's what they need, even on their figure of what they believe they need to save. And this is piled on years of cuts. Make no mistake, very few legal aid rates have changed since 1997.
You came into this occupation because you have a passion for it,
Yes.
passion for justice. How does this sort of impact on you on a personal level?
It's dreadfully disappointing. It's quite crushing in many respects. The vast majority, in fact, I don't really know many solicitors at all that came into this particular job, criminal defence, for money. If they did, they probably left, because frankly, you're not going to get much. I knew full well when I started defending that if I wanted loads of money, I would go to London, I'd be a commercial lawyer. I would sit at my desk all day and look at leases that are about this thick. That is what you do if you want to earn a lot of money as a lawyer, because that's where it is. Today, Mr Grayling's attacking personal injury lawyer. He's previously attacked, obviously, civil lawyers. So these sorts of lawyers have never really been in it for the money. Company, commercial lawyers, yes, they can still earn a fair amount of money, but criminal defence lawyers never have been able to. Part of the reason I do what I do is because if you give, as I said earlier, people fair chance equally before the courts and the courts convict them, then yes, then hopefully miscarriage of justice are minimised. There will still be some, but that's the way the system should work. And in a civilised society, it is the way the system works. What worries me is that for the sake of a few pounds here and there, and I appreciate 220 million is a lot of money, but in actual fact he doesn't need to save that much.
Well, it's a drop in the ocean if we actually went after the tax avoiders.
Exactly. Now some budgets are much bigger than that. Legal services for this country provide a lot of money in terms of selling their wares abroad. And the government can tout at the moment the criminal justice system is still, because of hard work of people in my position, I don't want to be too modest about it, but we work hard, we work long hours, we work out of hours. I go to the police station in the middle of the night. I'm still paid roughly the same as a teacher. So that is the position you have. You have still some goodwill in the system. You have a lot of very skilled, very able, very experienced people in the system. And to take all of that, throw it away and give potentially the jobs that we currently do to firms that won't do them as well, but will effectively, with the sole watchword of cutting costs, it seems to me you're throwing away something really valuable and you're not saving as much money as you think, and you're just downgrading what you already have, a civilised and useful criminal justice system. And whilst I'm not saying by any stretch that either David Cameron or Chris Grayling or Nick Clegg or any of those that are currently in power are trying to establish a tyrannical regime in this country, what you have to watch out for is, if you implement cuts like this to criminal justice, if somebody were to be voted in, And let's be clear on this, some tyrants have been voted in their countries, voted in democratically. If you were to get the wrong person sat in number 10, who decides, actually I am going to abuse my position, I will be tyrannical, it is going to be spectacularly easy for them to do it.
Thanks, Lee.